Good evening, everyone, and welcome to our MTSA event titled Where Will Brexit Leave Lawyers on January 1st? My name is Victoria Mukungu, and I am President of the MTSA, and we are delighted to have our guest speaker, Master Dominic Grieve, with us this evening. Before we get started, I would like to go over 3 points. 1, if you have any questions, please send those into mtsaevents@middletemplestudents.com. I will also post this address in the chat shortly. You can also message either myself or Robert privately, and we'll try to deal with as many questions as possible towards the end. Thanks to all those people who have sent in questions already. 2, please can you keep yourself on mute at all times unless you are called upon to speak. And lastly, 3, this event is being recorded and will be shared by our new MTSA YouTube channel, so you can watch it after or share it with friends and family. Without further delay, it gives me great pleasure to hand you over to Robert Allen, our fabulous mooting officer, who is going to be your host this evening.
Thank you very much, Victoria, and good evening, everyone. In just 15 days' time, the Brexit transition period will finally end. But where we'll go from there, it's still to be decided. But that won't stop us from speculating tonight. And to help us in that task, we're extremely fortunate to be joined this evening by Master Dominic Grieve to hear his thoughts on the latest Brexit developments and negotiations as negotiations in Brussels draw to a close. Now, it is so often said, but this time it really is true, that our guest needs no introduction. But nevertheless, we can attempt to give him one. Master Grieve was called to the bar at Middle Temple in 1980, following a degree in modern history from Magdalen College, Oxford. He was elected as the Member of Parliament for Beaconsfield in 1997 and held various roles whilst in opposition, including Shadow Home Secretary and Shadow Justice Secretary. In 2010, Master Grieve was appointed Attorney General by David Cameron, a role he held until 2014, when he left government following a dispute regarding the European Court of Human Rights. Later that same year, he was presented with a Lifetime Achievement Award at the Human Rights Awards for his defence of fundamental freedoms. In 2015, he was elected chair of the Intelligence and Security Committee. But it is, of course, Brexit that brings us here this evening. Brexit, which Master Grieve has summarised as national suicide. Master Grieve played an active and notable role in the Brexit process. During the last minority government, his speeches and tabled amendments held significant sway and influence. He lost his seat at the 2019 general election, but a year on, Master Grieve remains, and that's no pun intended, a prominent voice in the Brexit process and a highly respected authority on public law matters. Master Grieve has been described by his former colleague, Jacob Rees-Mogg, as perhaps the cleverest man in the House of Commons. He is, of course, no longer in Parliament, but their loss is surely our gain this evening. Master Grieve, the floor is yours.
Thank you for inviting me to join you this evening. Thank you for that very kind introduction. All I can say is I think Jacob Rees-Mogg was flattering me because on the face of it, I appear to have failed in my political aims. Therefore, I think he's in a position to say kind words now that I am out of the House of Commons. And I think one might also argue out of his hair, which he may be quite pleased. You've chosen a very interesting topic this evening because, of course, as so often happens with Middle Temple moots and discussions, the words, where does Brexit leave lawyers, can be interpreted in a whole range of ways. What I thought I would try to do this evening was to look briefly in an opening discussion at what I think are some of the main themes that emerge from Brexit which are relevant to lawyers, as well, finally, as just touching on the fact that, of course, Brexit, as I know from working on the Bar Council Working Party on Future Relations, has created for some members of the bar who have practices which are either European in scope because they're European law related, or indeed to international work within the European Union in a state of total uncertainty. And that uncertainty, I regret to say, continues at the moment because we have no idea whether what rights of work or audience we are likely to have in Europe after this is over, and also the ability of European lawyers to come over to this country and cooperate with UK and English lawyers in doing work. But that's perhaps a slightly separate and discrete issue. Let me therefore start by looking at what I think are some of the broad themes that lawyers ought to be paying attention to. And in doing it, I should just start by prefacing my remarks by saying that this is a pretty rich theme of study for lawyers. But those of you who are listening to me have got to understand that I can't put myself forward as a wholly dispassionate commentator about all this, because some of the issues that have arisen from Brexit have involved me directly in my career as an MP and indeed contributed to bringing it to an end. So as good students, those of you who are, you will have to take that into account in evaluating my opinions. But despite that, I want to reassure you that I'll try to bring some objective legal rigour to my thoughts. First thought, we shouldn't be surprised that Brexit has created such a turmoil of what I think could best be described as a form of legal chaos. Our participation in the EU for 46 years was in itself a process of major legal and constitutional change. It was in October 71 that Edward Heath, as Prime Minister, secured the support of resolutions in both the Commons and the Lords for the UK to join the EEC. A year later, that was in the year that followed, that was given effect by the famous or notorious European Communities Act 1972 that one or two of my colleagues, including Jacob Rees-Mogg, keep on banging on about. And its clauses gave primacy to what is now EC, or was then EC, now EU law in our country. And Parliament and the United Kingdom chose, in furtherance of the Treaty of Accession, it did it because it believed it was in our national interest to allow the Court of Justice of the EEC, now of the EU, to override UK statute law if there was any conflict. But of course, and since then, of course, there have been 20 further treaties as the relationship has changed and our involvement has deepened. Most of those have added to the legal order that EU membership creates, and which was necessary to ensure that the agreed rules governing the interaction of member states and the European bodies was respected. People often think of the European Union in relation to the Commission in Brussels, a sort of Byzantine entity full of big, long corridors in a Berlaymont building where detractors of the EU see effectively as commissioners, unelected, going about the business of manipulating the way in which the EU runs and member states conform. But the truth, and as I know this from my time as the Attorney General, so you really want to understand where power lies in the EU, it lies in its legal order. The Luxembourg Court, which I've had the pleasure of appearing, I can't say I think very much of the building, which is Brogdinian, and I suspect is intended to be, is an absolute assertion of the supremacy of legal order in the EU. And I would add that one of the fundamental mistakes, which I think some of my colleagues have made in the process by which we have left the EU, stems from the fact that they have misunderstood the nature of the EU as a legal order and have imagined, one might even suggest the Prime Minister is still doing it, that it is possible to have on-the-side negotiations which will resolve eyeball to eyeball a discussion or debate or negotiation between two sovereign entities, the UK and the EU, when in fact what we are trying to do is to disentangle ourselves from a complex legal order underpinned by international treaty obligations. And this, I think, gives rise and has given rise in the course of Brexit to quite a few misunderstandings. Now, the first thing to understand, I think, about leaving the EU is that the legacy of the EU, despite the fact that we are leaving transition on the 1st of January, is not going to disappear. On the contrary, the most remarkable feature of our leaving the EU is the extent to which the UK government, in the process of doing so, has had to take vast chunks of EU law and preserve it, even if the supremacy of the EU, of the European Union Court of Justice, is going to be removed. You'll recall that the government back in 2018 brought in, or late 2017, brought in the EU Withdrawal Act that was described at the time as a great repeal bill. But actually it was absolutely nothing of the kind. On the contrary, it was intended to entrench and convert EU law into domestic law to avoid our falling into a void of lawlessness on the first day after our departure. Now, of course, that didn't occur because we went into transition. I'll come back to that later. But that is where we are going to go, subject to any treaty which we reach with the EU in the next 12 days. That is where we're going to go on the 1st of January next year. Now, one has to just take into account how big the void was that was looming for us as a country in legal terms. My reckoning is that EU membership has involved 40,000 legal acts, 15,000 court verdicts, and 62,000 international standards, which are binding on citizens and companies in the UK by virtue of that membership. The bill, the Withdrawal Act, now an act, which will kick in with such momentous consequences, was a monster of a piece of legislation, although nowadays people seem to have half forgotten it. But it took EU law, but rather than retain it as a block, it tried to discard elements of it which didn't suit the government's political agenda, whilst retaining those bits which did. Just to take a few examples. EU directives implemented by either primary or secondary legislation, now to be known as EU-derived domestic legislation in clause 2, EU regulations referred to as direct EU legislation, clause 3, directly effective provisions of EU law, clause 4, are retained insofar as not repealed by UK primary legislation. But at the same time, the government then excluded the Charter of Fundamental Rights in clause 5.4 of the Act, nevertheless allowing general principles of EU law to survive, along with the ability to make continued reference to the Charter, but only insofar as it's necessary to interpret retained EU law. Principle of the supremacy of EU laws retained, but only as regards laws enacted prior to exit day, where the modification clearly intends to preserve that supremacy. But it's then made clear that from exit day, there will be no right of action in domestic law for any failure to comply with general principles of EU law. Those general principles, I might add, are nowhere defined. Now, you may find that quite muddling, in which case, please don't worry, because you're in very good company. I think the key thing to understand of the process of our leaving the EU in legal terms is that the legislation that we passed in the EU Withdrawal Act reduces both the Charter of Fundamental Rights, to which I'll come back in a moment, and general principles of EU law to no more than interpretative aids. The protective rights previously provided to ensure EU law couldn't operate abusively evaporate, leaving only the possibility of a challenge under the Human Rights Act. The justification the government gave for that was that it was wrong, as we were leaving the EU, to allow any element of judicial supremacy inherent in the way EU law operated to survive, as it offends that magical thing called parliamentary sovereignty, which Brexit is supposed to restore. The possible alternative of allowing our own Supreme Court to fulfill that role, unless or until we replaced EU law with our own domestic law, was rejected by the government. And that, I think, is the start as we look at Brexit, of the creation of a fairly fundamental anomaly. One of the principal complaints about EU law is it was either forced on Parliament, which then had to enact it, or worse still, could be directly created by the Commission. Yet to maintain predictability, we're preserving its supremacy in relation to pre-Brexit primary legislation, and we're also treating all direct EU legislation as primary for the purposes of the Human Rights Act, when an awful lot of it looks to me exactly what we would classify in English law as a statutory instrument. That therefore means that it can't be examined or challenged in court. The only exception to that is the CAP regulations. Implementing regulations are made by the EU Commission using delegated authority and therefore, as I would suggest, look very similar to a SI, but will be treated as primary. Again, the only possible challenges to it will be under the Human Rights Act. In the meantime, challenging it, if it leads to injustice or abuse of power, will be very difficult. In a remarkable arrogation of power, clause 1.2b leaves open the possible creation of the right to challenge retained EU law for being invalid at the date of exit, but only if the challenge is, and I quote, of a kind described or provided for in regulations made by a minister of the Crown. I don't think I can think of any other example, I should be interested for the conversation afterwards, of an important legal right being created or denied to people in such a fashion by the executive. So, first point, the legacy of EU law, I think irrespective of whether we have a treaty on departure, is going to live on through the EU Withdrawal Act. It's going to live on in a very strange hybrid form, one which I think is profoundly unsatisfactory because it has sought to separate EU law from its fundamental principles, which lay in the Charter of Fundamental Rights, which an awful lot of my colleagues didn't like because they saw it as a sort of Human Rights Act Mark II that could, in some circumstances, override UK law. But the result end is a mishmash which I suspect will provide a fertile field for lawyers and may well prove to be very unsatisfactory. Second point about leaving the EU. Second thing which I suppose one can say about leaving the EU is it has provided some fascinating lessons in constitutional law, UK constitutional law. Obviously, that centres on the two Miller judgments. Those are, I think, very different cases, and I shall just look briefly, because I don't want to take too much time before the discussion, on each of those Miller cases. Miller 1, to use the expression, was, of course, a case concerning the right of the government to exercise the royal prerogative power to make and break treaties in order to initiate the Article 50 trigger process and start our departure from the European Union. It was a fascinating legal question. The government took the view that as the original adherence to the EEC had been by treaty through an exercise of the royal prerogative, backed by a resolution of both Houses of Parliament, it could trigger Article 50 as an exercise of the royal prerogative as well, and actually had also had a resolution of both Houses of Parliament approving it, or certainly a resolution of the Commons, but not the Lords. It could correctly highlight that nothing in the 1972 Act excluded the use of the prerogative power to negotiate and adhere to treaties in respect of the EEC. Now, Gina Miller and others disagreed. They went back, interestingly, to the 17th century, to Sir Edward Coke and his case of proclamations. The king, by proclamation or other ways, cannot change any part of the common law or statute law or the customs of the realm. Something I might add that Sir John Fortescue had also said as far back as 1454. So when we're talking about English exceptionalism, it definitely falls into this category. Her challenge was also joined by one which came from Scotland and Wales about whether Brexit could take place without the assent of the Scottish Parliament and the Welsh Assembly. Now, the judgment at first instance in the Miller case saw the government's case dismissed as flawed at the most basic level, but the Supreme Court judgment is fascinating because it said, in its majority view, that the 1972 Act had effectively constituted EU law as an entirely new and overriding source of domestic law. It therefore said it had a constitutional quality and only primary legislation could overcome it. And in doing that, it was acknowledging the fact that as a result of the treaty that we had signed up to, vast swathes of primary legislation had then come in, of which UK citizens would be deprived if we left, including some which were standalone pieces of legislation, such as the right, for example, to vote for NEPs in elections. Now, I've always seen this case as a rather esoteric point of law, a very important one because it's probably the most significant boost for Parliament against the growth in the last century of executive power that we have had. And it clarified in a way that I think was really important the impropriety of trying to use executive powers to undermine and remove rights conferred by statute. Obviously, as you'll be aware, it was followed by an extraordinary attack on the judiciary, who were described as enemies of the people. I don't want in this discussion to get too weighed down in the politics, but it did strike me at the time that we were beginning to behave like a banana republic in terms of the stridency of the criticisms, which were completely misplaced. And I also have to say I greatly regret the fact that some people in government, including the then Lord Chancellor, did not, in furtherance of the oath she had taken, stand up for the judiciary's independence and right to decide these issues, openly joining virtually with the criticism that was being made of them. The second prerogative case, in which I suppose I had an intimate involvement round the edges, was of course Miller 2 on the prorogation of parliaments. That I've always thought was a very different case because it arose not from some esoteric point of law, but from the fact that in the course of 2019, when Theresa May had failed to get her deal through Parliament and had then had to quit and been replaced by Boris Johnson, the government of Boris Johnson and Boris Johnson himself tried to cut through the opposition of the House of Commons, where there was clearly a majority against no deal, tried to cut through that opposition by simply adopting unconstitutional means to achieve its end. Firstly, it didn't tell the truth about its intention to try to prorogue. The evidence is overwhelming that they actually told lies to the media about whether they were going to do this at a time when they were plotting it, including, I might add, telling the Court of Session in Edinburgh that they had no intention to prorogue when they were working on it themselves. Secondly, in proroguing, being unable to provide any sort of credible explanation as to why they had prorogued Parliament. The argument they put forward was that the prorogation was normal, whereas in fact its length was abnormal. And they could give no explanation as to why they'd done it, because there was nobody in the civil service who was proposed to swear an affidavit, which would be untrue, as to and they were unwilling to allow them to swear an affidavit which would be untrue, which was that they decided to do it to marginalise the House of Commons and the House of Lords in the immediate run-up to a negotiation with the EU on leaving, because they thought it would strengthen their hand with the EU and enable them to present Parliament with a fait accompli in mid-October 2019. So that case on the prerogative was, I think, very different. And of course, it led not to a majority decision, but to a decision which was unanimous and which stated that the prorogation that had been carried out was unlawful because the Prime Minister, and I think this was quite an important aspect of it, the Prime Minister was under a duty not just to consider his own party political advantage, but to consider the constitutional propriety of prorogation and the fact that our own constitution, unwritten, is dependent on Parliament existing to act as a check on the executive and to challenge it. So I think it's one of the most important judgments we've had from the Supreme Court in all its time in existence. I think it was absolutely correct. And it came, as I say, not from an esoteric point of law, but from a fundamental legal issue, which was about how government should conduct itself in an environment. The point of the Brexit process, which I thought we'd touch on, was the Internal Markets Bill. The Internal Markets Bill highlights, I think, some fundamental issues which relate to sovereignty. We talk in the context of Brexit of somehow getting sovereignty back. But the difficulty is that quite apart from our EU membership, the United Kingdom has been diluting or sharing its sovereignty whilst retaining ultimate rights over it for at least the last 200 years of its history, and probably rather longer. When I was Attorney General, I once asked the Foreign Office, how many international treaties is the United Kingdom signed up to? And the answer came back after a lot of humming and hawing from the Foreign Office, because they were a bit put out by this request. But back in 2013, they calculated that we were signed up to 13,400 treaties, which were still extant and operational and binding on the United Kingdom, ranging from the UN Charter, the European Convention on Human Rights, maritime access treaties bilaterally with remote nations. We are probably, as a country, the biggest treaty-making power in global history. And we've done that because we took the view that pooling sovereignty in this way, and with the effect of fettering also the sovereignty of others, meant that we could create a rules-based international system which was more predictable and more likely to preserve peace than the anarchic free-for-all of unbridled sovereignty by every nation. And we have been probably the biggest upholders of that system throughout our existence. And of course, one of those areas where we pooled sovereignty was back over the relationship between the United Kingdom and Ireland. And this goes back a long way. When Ireland became independent and finally became a republic, we chose not to treat it as a foreign country. It is there in a piece of primary legislation enacted by the UK Parliament back in 1949. And of course, linked to that was the Belfast Agreement of 1998, which was a way of resolving the strife in Northern Ireland, which actually had in its preamble the reference to the wish of Britain and Ireland, or UK and Ireland, to develop still further cooperation between our countries as friendly neighbours and as partners in the EU. So leaving the EU has created major problems for the constitutional position of Northern Ireland and our respect for the Belfast Agreement. And it was why Theresa May, when she was Prime Minister, took the view that there could not be any arrangement by which the UK left the EU which did not involve the UK as a whole, because she did not wish, as a unionist, to see Northern Ireland carved out economically or constitutionally in any way from the rest of the United Kingdom, whilst also seeking to respect the Belfast Agreement. That was what Boris Johnson described as the vassalage clause, which led him to break with Theresa May in the summer of 2018, and may arguably have led to Theresa May's undoing. And of course, Boris Johnson's solution, when he was prevented from achieving a no-deal Brexit in October last year, was to go over and talk to Leo Varadkar, the Taoiseach, and the European Union Commission, and indeed create the Northern Ireland Protocol, which was significantly different from Theresa May because it did envisage carving Northern Ireland out of the UK economically, as some of us pointed out at the time. Although if we obtained a free trade agreement with the EU, then in those circumstances, it would supersede the protocol. As you'll be aware, as the negotiations started to founder, the government in the Internal Markets Bill chose to introduce the notorious clauses which were described as a specific and limited breach of international law, namely the very obligations we had signed up to only 11 months previously. Now, as it happens, this appears to have died a death, because interestingly, it blew up in the Prime Minister's face. If it was intended as a piece of leverage in our relations with the European Union, it does not seem to have been successful, because even Brexit supporting peers like Lord Howard, Michael Howard, decided that it was a step too far, and it's certainly done the United Kingdom an immense amount of reputational damage in attempting to enact this legislation. I can't read the mind of my colleagues in government as to why they did it. I can only say that for a country which sees upholding the international legal order as being an absolute key as to the way we operate, and indeed used to incorporate it in the ministerial code, what we decided to do was really quite astonishing. But it's gone. But I think it all does raise for the future the question as to whether this is a form of behaviour that United Kingdom governments intend to return to. Because if they do, then the international legal order to which we're signed up, which used to be enshrined fully in the ministerial code, and I believe is still there, despite the interpretation of it by the current Attorney General, one of my successor, but two, is a very curious outcome. And I think that's an issue which may well come back and will need to be looked at. So I've covered, and I hope briefly, and inevitably not as completely as I might like in initiating this discussion, three areas: the retained EU law itself and our relationship with the EU, prerogative and constitutional issues, international law. Of course, the one thing I can't cover, I think it was probably hoped I might be able to cover this evening, is what our future relationship with the EU is going to be. Either we are crashing out with no deal on the 1st of January. If that happens, the consequences are that we will be trading with the EU under World Trade Organization rules. And the long-term consequences, the short-term consequences of this, in terms of areas of current cooperation, which are included even within transition, will be very profound. Just to take a few examples, I have no doubt that trade will be held up at the border, because not only the presence of tariffs, but regulatory checks will create, at least in the short term, I would have thought, very considerable disruption. The second issue, which I think is rather overlooked, is that we have a very close security cooperation with our EU partners, which is entirely the product of EU law. That includes the Schengen access to the Schengen databases. It includes the DNA database. It includes our participation in Europol. And if we are leaving on the 1st of January with no future agreement on security of any kind, then all these will fall away. And we will suddenly find, for example, that we can't extradite anybody from Germany ever again, because the only basis on which the Germans extradite people to us is under the European arrest warrant, and they will not otherwise extradite their own nationals to the United Kingdom. So there the potential, I think, for very profound disruption, which I think will be immediately noticeable. But we don't know whether at this very moment we're getting very close to a deal. We don't know whether that deal includes security. It looks as if it probably includes tariff-free access, although not necessarily regulatorily free access for goods. Services, which the bar provides, are of course not covered in this agreement at all. Which brings me finally to where I started, which is that, of course, for those of you who had aspirations to have careers practicing EU law, then I think you should be looking around to see whether you're entitled to an Irish passport, or possibly the passport of another European nation, because otherwise it's difficult to see how you're going to be able to do it, except insofar, I suppose, as you can get called to the Northern Irish Bar, and you will find that as a consequence of the Northern Ireland Protocol, which the Prime Minister has now signed up to and agreed, even if we're leaving without a deal, actually, even the Charter of Fundamental Rights of the European Union will continue to apply to the operation of the protocol in Northern Ireland for presumably forever. So those of you who are interested to practice in that field, you may well find that you can still do it. I just think that probably we ought not to whisper that in the ear of one or two of my parliamentary colleagues who don't appear to have entirely grasped it. Now, I've probably spoken for long enough. I hope I've set the scene for a conversation. I'm here to have a conversation on anything you like on this subject. I've tried to stay away from the politics as much as possible, as this was a lawyer's discussion. But of course, I'm very happy to discuss. And it's very easy for me to talk about the politics of Brexit insofar as I've been involved in it. But do feel free, please, to raise with me any topics that you like. Thank you very much.
We have one which really has been covered in the end, but perhaps you could develop it a little bit more with respect to Northern Ireland and so on. Will one still be able to practice as a lawyer in Europe, and moreover make a contribution to European law post-Brexit?
Well, we don't know the answer to that. I mean, this has been one of the real problems that the Bar Working Group has been grappling with. And we've been having meetings with the Ministry of Justice. And of course, inevitably, the Ministry of Justice has given us an idea of the direction of travel that it's trying to achieve, but it's quite unclear what the outcome, if there is a deal, will be in respect of this. At the moment, the position is that there is a degree of mutual recognition of qualifications. So if I want to pop over to Paris to give advice on English law to somebody, I can do it. Obviously, I can't appear in the French courts without having a French qualification, and the same vice versa. But ultimately, the market in legal services, there is a market in legal services around the European Union, which operates, certainly for advisory work, in an open capacity. And you can go with whatever expertise you have to provide that advice. We can also go and appear in the European Court of Justice in Luxembourg. But all that is going to disappear. Now, it's clear that there will be, I think, some rights of audience in the European Court of Justice in Luxembourg, dealing with points depending on what the outcome is, even after we're gone, because in any area where the ECJ may have competence. Although, of course, the government is seeking to limit that competence completely. But the reason why I made my quip at the end about Northern Ireland is that I think the competence of the European Court of Justice in relation to the Northern Ireland Protocol is going to continue forever. And therefore, if you are an English barrister and get called to the bar of Northern Ireland and there is a point of law, I could see you end up in the European Court of Justice arguing it, because your rights of audience there will, I think, be preserved whatever else happens. But clearly there are a significant number of UK barristers who have made their careers on EU law. Now, some of those skills will doubtless continue, because as we've retained so much EU law, the continuing interpretation of that in a domestic law context is clearly going to be available for people, because a lot of EU law, as a source and origin of EU law, is going to continue. But the question as to our rights of audience is completely up in the air. And the other issue, which is completely up in the air, is about mutual recognition of judgments. The EU has indicated, there's the Brussels I and Brussels II conventions, and there's Lugano. And at the moment, the EU appears to be blocking the United Kingdom adhering to the Lugano Convention. So we simply don't know where that will end up. And of course, mutual recognition of judgments has been a very important issue, particularly in areas like family law. And at the moment, we don't know at all where that's going to end up.
Moving away from our mutual recognition of those judgments, how persuasive do you see EU case law being in the UK courts from January?
I mean, I think it's clearly going to be of importance, because any area of retained EU law, I certainly think that the advocates appearing in court will be entitled to cite EU law cases in front of the European Court of Justice, even those which post-date our departure. Just in the same way that if you're doing a common law case, you can cite a case in the Australian courts on a common law matter if you think that it's germane to the judgment which is taking place, even though we're completely separate jurisdictions. But what is clear is that once we have gone, then except in these rather esoteric areas of primacy, EU law as it develops thereafter will not trump our own the judgments of our own courts. One of the issues which is still, I think, slightly unresolved is the extent to which the courts will have, when we enacted the EU Withdrawal Act, we restricted reinterpreting EU law to our Supreme Court and the Court of Appeal, but I'm not entirely clear whether the EU Withdrawal Agreement Act doesn't extend it again, and it's something which I'm a little bit at a loss to understand what the government is trying to achieve. So I'm afraid I'm a bit confused on that and better not confuse you. But my understanding is that ultimately the primacy of EU law may be retained over domestic law in certain areas, but that's only because of the EU Withdrawal Act's impact and nothing else.
On a few wider points, the next question actually concerns the very reason that you left the government in 2014. Given the government's recent actions and the statements that it's made, do you believe that the Human Rights Act is under threat? And if so, do you believe that our fundamental rights themselves are under threat?
I just don't know what the government is trying to do with the review of the Human Rights Act. It's worth perhaps just remembering that this crept into the Conservative Party's discourse around 2006. David Cameron was the initiator of a view that the Human Rights Act was not working as intended, was leading to rights creep, including rights for undeserving people against the rights of the majority, and said that he wanted to have it reviewed. And he started to use the expression, I want to scrap the Human Rights Act and replace it with a UK Bill of Rights. And when we were in opposition between 2007 and 2010, he asked me, and I was then the Shadow Attorney General and then the Shadow Home Secretary, if I'd carry out a review. And I did that for him, including bringing some independent people to help us. And the conclusion which we came up with was that if you are going to remain adherent to the European Convention on Human Rights, then the wriggle room to change the Human Rights Act is minute. And whilst you could use a British Bill of Rights to add to the rights in the Human Rights Act, and perhaps in one or two places define them very slightly differently, it was not going to have any significant impact. I'm not sure David Cameron liked hearing that, because he put my report in a bottom drawer, and indeed it's never been published. Coalition governments then formed, and in order to satisfy the promise he made in the Conservative manifesto, a Bill of Rights Commission was set up, independent. Of course, that produced a split decision. It had no majority view, but if you go and read it, and there's dozens of pages, of hundreds of pages of text, it comes up essentially with the same conclusion. David Cameron then put it in the manifesto in 2015 that we were going to scrap the Human Rights Act and have a Bill of Rights, and that if that meant that we were incompatible with the European Convention on Human Rights, he would consider derogating from the European Convention or indeed being forced to leave it. He was never able to do that. It didn't happen. It's been lurking around in limbo. Theresa May dropped it. It is now back in the Conservative Party manifesto, and that is what is leading to the latest Bill of Rights Commission being set up, or Human Rights Act Commission. I can think of no reason to conclude that they are going to be able to come up with a different solution. So to answer your question, is it possible that that could then lead to a government saying, all right, we're going to leave the European Convention on Human Rights? Well, I think it is, but it's a pretty seismic thing to do. And seeing that we're about to leave the EU finally at the end of transition, to then jeopardise our position. Indeed, I think we would have to leave the Council of Europe, which is the forum in Europe where Britain has always been seen as taking the lead, and is the remaining major European forum in which we operate, does seem to be an extraordinary decision to take. And yes, if we were to repeal the Human Rights Act and leave the European Convention on Human Rights, then the potential for our rights to be infringed, or things that we now regard as our rights, are clearly considerable. I don't think we can escape that. But if you're asking me, do I think this is actually going to happen in reality, I have, fortunately, doubts about that. I just do not think how, in terms of realistic politics, this makes any sense at all. So I'm afraid I think this is another piece of both playing to the gallery and a bit of can kicking. So I would not despair on this subject. I'm going to be working on a working party to feed in our own thoughts set up by Justice on this subject. So I will have an opportunity to say my pennyworth about it. We don't even yet know exactly who's going to be on this commission, I don't think, unless it's been published in the last few days. I certainly haven't seen it. And I shall be very interested to see what the outcome of it is.
Linking to that, and of course the wider Brexit process, are you one of those people who is of the view that in these very uncertain times, Britain would benefit from a written constitution?
I'm on record as giving quite a few lectures in sort of 2015-16, when I was freshly out of office, in which I said, yes, there are good reasons to have a written constitution. One of the things I didn't touch on this evening in my talk, but I can touch on now, so in a sense I will have touched on it, is the impact of Brexit on devolution. Devolution presupposed that we were met in the EU, and as you will be aware, large numbers of powers which nominally lay with devolved authorities in the United Kingdom were in practice exercised by Brussels. So their repatriation has created a particular problem for the United Kingdom government as to whether those powers get repatriated to Scotland, Wales and Northern Ireland and then exercised from there, and what the potential impact would be, for example, on the internal market of the United Kingdom. And the other part of the Internal Markets Bill, the bit which didn't deal with overriding the EU withdrawal agreement entered into last year, or very early this year, I think actually it was signed. The bits which didn't deal with that were trying to provide, or have tried to provide, a framework for managing those repatriated powers. And the devolved authorities are not pleased with what the government has done. I have slightly more sympathy with the government over that issue than I had over the breaches of international law, but it is true that it is a very unsatisfactory state of affairs. And the truth is that devolution has proceeded in a piecemeal manner. Some bits of it were not well thought through. We have tried over time to improve it. So, for example, Wales has now moved to instead of devolved powers to reserved powers, to we've changed the basis of Welsh devolution to make it similar to that of Scotland, which just devolved everything except what's been reserved rather than the other way around. But in the process, it's thrown up quite a lot of problems. So when I was giving these lectures in 2014-15, I often said that I thought there was sound reasons for looking to have a written constitution which could do a number of things. I thought it didn't have to be a very complex written constitution, but it could include a Bill of Rights which had the Human Rights Act in it. It could include a better definition of devolution and the respective powers of the devolved parliaments and assemblies and the UK government. And it could also try to include some defining constitutional principles, which we've currently been grappling with. And for example, we've been looking at the power to prorogue Parliament, for example. So and also the lengths of parliaments and dissolving parliaments. All that could be included in it. We could bring together things which are in the Representation of the People Act and elsewhere and merge it all together. And I thought it might help people have a feeling of ownership, that this was a UK Bill of Rights or proto-constitution in which people could actually say these are the defining basis on which the United Kingdom works. But I fear this is perhaps a slightly Cartesian way of going about things for the dear old UK. And the hard truth about it is that I don't think it's ever going to happen, particularly as long as we are in political crisis, because nobody can afford the time to do it. And the trouble is that when you're not in political crisis, nobody has any incentive to do it. My hunch, and I'm sorry to sound very pessimistic, but my view is that England will get a constitution if the United Kingdom breaks up. Because that will be the moment when people say, we've got to do something about this. Unless or until that happens, I think it's most improbable that the building blocks are present to enable it to happen. It would need a government elected in a period of relative constitutional calm and with authority, or enough authority throughout the whole of the United Kingdom to be able to manage the process, to hold the citizens' assemblies, to hold the consultations, to hold the debates in Parliament, which would lead to creating something which people really wanted and or felt that they could recognise and support. At the moment, I just don't think the preconditions are there. And in fairness, some people say that Brexit has shown, or say, oh, Brexit's shown our constitution is broken. I don't think I necessarily agree with that. It shows our constitution is under immense challenge, but actually, you look at the two Miller cases. You look at the way the House of Lords behaved over the Internal Markets Bill. Look, for example, and I didn't have time to touch on it, at the way in which Parliament did actually significantly amend the EU Withdrawal Act to try to limit the operation of the Henry VIII clauses which were contained in it. The other thing in the EU Withdrawal Act was the sheer extent to which it gave power to the executive. And actually Parliament set up a system for trying to scrutinise that. Now, all those things suggest to me that our constitution as it stands is actually quite resilient. And then look at the events of 2019, in which I was heavily involved. The then Attorney General described Parliament in rather memorable terms on the 25th of September last year as this useless dead Parliament. I disagree. Parliament was actually operating very successfully and independently in challenging a government which didn't have a working majority. And the matter was ultimately resolved by the holding of a general election, which the government then won with a majority sufficient to carry out what it wanted. Now, I may be the loser from that process, but does that suggest to me that Parliament wasn't functioning properly and the Constitution wasn't functioning properly of the UK? No. It suggests to me, actually, that it was showing a certain amount of resilience based on perfectly clear historical principles, including the reassertion of the power of the House of Commons against the executive, something which hadn't happened before because we've never had a period of minority government with such fundamental issues having arisen in that form, where the government didn't have a majority effectively to push its will through Parliament.
Do you think in whatever the constitutional settlement we have, there is a place for referenda within it?
I think the lesson is that referenda are very dangerous. Let's just take a couple of things. I think referendums are probably here to stay, so I don't think we can lightly dismiss them. But it's one thing to hold a referendum on a clear choice where the consequences of that choice are immediately apparent in legal terms. It's, I think, another thing to hold a referendum on, as we did with Brexit, or indeed was done with Scottish independence. It's the other one which really springs to mind, where there is no understanding of what the consequences of the subsequent negotiation is actually going to produce as the end product. I think that's an immensely dangerous way of proceeding. And I hope we never have a referendum of that kind again, or if you're going to have such a referendum system, then we really do need to have a second referendum when the negotiation is finished to ask for people's approval, because the argument in favour of the second referendum, which made me slightly reluctantly come to the conclusion was the best way out, was that we'd reached a stage in 2019 where our departure from the EU bore absolutely no resemblance to what was being debated in the 2016 referendum. We were doing things that leavers had specifically said would never happen. And yet, the argument was that because the people had decided in 2016, there was and could be no opportunity for people to change their mind about it. So those sorts of referendums bother me. But where you have a referendum which is offering a choice, particularly a choice between the status quo and change, where then I think that provided there's clarity, it can sometimes be helpful. I mean, just to take an example, you can argue, and I mean, here I have some sympathy with my Brexiter colleagues, that if we had had a referendum over Lisbon or Maastricht, then the chances are quite high that the public might have rejected one or other of them, or both. If that had happened, the EU, the UK government, could not have signed up to the changes that they were going to bring about, and it would have stopped those areas of European Union development in their tracks, which we had the perfect power to do. That's a very different thing from holding a referendum on withdrawing from existing obligations, rather than the creation of new ones. And that's, I think, where one has to be so very careful. Just to take another example, the Irish had a referendum on abortion. Now that seemed to me to be rather a successful referendum. It was preceded by extensive public debate and discussion. And of course, it was quite a simple issue. And so ultimately, it was an issue which divided Parliament, and Parliament didn't feel it could take, and by the Dáil could take, and so it was left to a majority of the public to determine what they wanted to do. And that strikes me as having been quite successful, but it's very limited in scope. I think referendums can be very, very dangerous, and the Brexit referendum has shown, to my mind, just how dangerous it is, because it left the public with expectations that couldn't necessarily be fulfilled. It left parliamentarians with an obligation. I regret having signed up to it. I mean, I was reluctant about it at the time. I was a backbencher. David Cameron asked us to vote for it, and we did, because I felt under an obligation to do it because it was in the referendum, in the manifesto, of 2015. I think only Ken Clarke on the Conservative benches voted against it. All credit to him. But I didn't. I voted for it because I went along with the promise the Prime Minister had made. And everything I've seen since has made me regret it.
Well, it's just gone 7 o'clock, so I'm conscious of bringing everybody in. So I think what we'll do is have one more written question for now, and then open it up to the floor. Victoria will have a look at whose hands are raised. So if you'd like to raise your hand, I understand there's a function for doing that. Raise your hand if you'd like to be brought into the discussion, we'll do that. And then if there is time at the end, we can come back to written questions. But one more for now, and there has been a few questions on this theme actually, so it's clearly of interest, slightly more political, this one. What is your view, Master Grieve, on the Home Secretary's recent attacks on the legal profession? And do you think the pursuit of Brexit has contributed in any way to the attacks on the judiciary's independence, particularly with respect to those Miller judgments?
Yes, I mean, to take the second part first, because actually I think the second part should be taken first. I'll come back to the Home Secretary in a moment. Yes, I think one of the most difficult and worrying aspects of the referendum process was that it created this thing which was unknown to Dicey when he wrote his constitution, his analysis of the UK constitution, this thing called the will of the people. And that was exploited by the media to argue that effectively Parliament had been reduced to the mere agents of the people to implement the Brexit that they had demanded, even though that Brexit was undefined. And it created an atmosphere of hysteria that I've never seen previously in the UK. When I said earlier, I think in my remarks, that there were times when I thought we were sort of sinking into being a banana republic, where the media were agitating about decisions of the judiciary, which were in fact perfectly, you could disagree with them, but to argue that they were somehow far-fetched or fell outside of the norm or were showing the judiciary to be unreasonable was simply not correct. And that first attack on particularly the Divisional Court and the Lord Chief Justice in Miller 1, enemies of the people, as I said at the time, you know, the last time I'd seen a headline like that was as a student at university in reading the Nazi press when it started its denunciations of public officials who were seen to be opposing the Nazis' changes to the way in which Germany's administration worked in the period immediately after they'd got to power. They used that, enemies of the people. And I hadn't seen it since. And I think we should be very concerned about that. And as I mentioned in my comments earlier, the then Lord Chancellor, Liz Truss, who takes an oath of office respecting the rule of law, firstly said nothing for 24 hours. And it turned out that the reason why she said nothing was because she was waiting to be told by number 10 what to say, whereas it's quite clear that constitutionally she has a separate role in protecting the rule of law, which has nothing to do with number 10 Downing Street at all. And she should have acted independently. And secondly, when she spoke, said, well, of course, you know, judges are entitled to say what they like, to their decisions, and those must be respected, but the public are entitled to effectively attack them. Well, the public is certainly entitled to criticise decisions, but not to stand up for the judges who can't defend themselves against what were grossly abusive attacks, I thought was very bad. So what we have seen through the Brexit process is a coarsening of the political discourse. Again, I don't want to exaggerate it, and it didn't just apply to me, but I found myself, and some of my colleagues found themselves, the object of vilification in the press, and then that tended to get followed by death threats. In September last year, rather notably, the number 10 press unit, I think this is a first, put out a statement to the Mail on Sunday that Hilary Benn, Oliver Letwin and myself were receiving money from foreign governments to formulate the Benn Act, which, as you may recall, stopped the government from forced the Prime Minister to ask for an extension before the 31st of October. That we were in the pay of these foreign governments and we were going to be the subject of an inquiry by the government in which our mobile phones would be seized and examined so that the compromising content could be identified. And I can tell you, I got a lot of death threats in the 36 hours afterwards about this. In fact, it was totally and completely untrue. It was untrue, both, firstly, that we were not in the pay of foreign governments. It would be a terrible breach of parliamentary code of conduct if I hadn't disclosed that I was receiving money from foreign governments. And on top of that, there was no such investigation taking place because the government never had the power to do it. But the government actually chose, through, I suspect, 2 individuals who have since resigned very recently from the Prime Minister's staff, to tell that to the Mail on Sunday. Now, what does that say about the state of our democratic politics? Of course, democratic politics are robust and shouldn't be for the faint-hearted. But I think we've always tended to have a framework in the UK that you can spin things, but you don't go around telling outright lies. And you don't vilify people, and you certainly don't try to raise hatred of others. But I'm afraid to say the Brexit process has done those things. And there have been times when it's spilt over. Now, this may all be a blip, and it may all go away. And that then brings me to the Home Secretary. The Home Secretary is entirely wrong in the remarks that she made. It would be perfectly proper for her to say that she felt that there were occasionally to criticise lawyers if they've been found to have behaved badly. But there is no evidence that a lawyer who's taking a legal point which finds favour with a court preventing, for example, somebody being deported at the last minute, is acting improperly. One must assume that in acting, they weighed up the interests of their client, which have to be paramount, that they didn't mislead the court in presenting the case, and that it was the court which decided that it would halt the deportation because there was still something to be considered as a matter of law and fact. So how can they have been acting improperly? And this sort of discourse is not good, and ultimately will come back and bite the government. And governments in mature parliamentary democracies should not engage in that. Of course, it's irksome at times. I was Attorney General. I saw plenty of examples where court decisions could be irksome, sometimes cause government embarrassment, but governments should take pride in the fact that sometimes they may lose a case in court. It's part of the process which shows that the rule of law and democracy are working hand in hand.
Excellent. Well, we've got 3 hands, I think, at the moment, which are raised. And anyone else, feel free to raise your own hand. I think we've had Bobby Shabir waiting very patiently as I've been asking the written questions. So if Bobby would like to come on, if you're still wanting to ask a question, Victoria will allow your microphone, and I think you'll have to approve access. Just see if we hear anything. Bobby Shabir, I think you're still on mute at the moment, but you can come on now if you'd like to. If not, we can come back to you. And I think we've also got Ben with his hand up. So Ben.
Hello, can you hear me?
Yes, I can, thank you.
Yes. Thank you for that interesting talk, and I'd like to say thank you for standing up in the Brexit process, because I know myself how terribly divisive and everything it was. My question to you is, in recent weeks we've seen the rise of racism being highlighted within legal systems all over the world after the death of George Floyd. And a couple of years ago, David Lammy wrote the Lammy Review, and the government have not implemented one of the recommendations. And as a pinnacle and a cornerstone of the rule of law is that there is equality in the law, no one is above the law, and everyone is equal before the law. So do you agree that the Lammy report should be implemented in full, and more needs to be done to tackle racism within the legal system?
Can you just remind me a moment the specific thing in the Lammy review which you say hasn't been implemented?
None of it have, and especially when it comes to stop and search, black men are 9 times likely to be searched compared to white people such as myself. So do you think that the government needs to do more about this, and not just the government, all political parties?
We all face a challenge in our society about racism, and there is absolutely no doubt that, as Theresa May, when she was Prime Minister and also as Home Secretary, you may remember that she changed the stop and search rules because she was so concerned at the extent to which they were stopping and searching young blacks more than anybody else. And that remains a real challenge. So I'm certainly in favour of constant scrutiny of the legal system in its widest sense. And I think by this you meant not so much the legal system, but actually the policing system we have in this country, as to whether it's operating in a biased way. The difficulty, though, is that ultimately there is a requirement to enforce the law without favour or fear. And that also means targeting areas of criminality which are of greatest concern. So if you end up with a situation where knife crime, as appears to be the case, from where, when I was a boy, knife crime was associated principally with gangs in big urban centres. Is still the case in many respects, but the evidence is fairly clear that the victims of knife crime are almost entirely, not entirely, but very largely drawn from within the black community in Britain and black communities. So what does one do about that? And I think that's the challenge for law enforcement and the challenge for all of us, because you can't simply escape the facts, the statistical facts. And so the police would argue, well, if it's true that we're carrying out more stop and searches in areas where we think there are gangs operating, because that's where the statistical base tells us they are there, and in the process we're stopping more young black people, that is a very difficult issue to find a solution to. And I think we have to also show some sense of realism, but we also have to have an understanding what the impact is on communities that feel that they are being over-policed. There's never been a solution to this. And I think only the application of some pragmatic common sense is likely to be helpful. As for bias within the criminal justice system, yes, there are all sorts of areas which I think we should be concerned about, whether in fact there is evidence of bias that people from ethnic minorities receive tougher sentences, for example. I think there are a whole series of things that we need to take seriously. My answer to your question is the Lammy Review, and David Lammy is a friend, and I know him very well, is an extremely well-intentioned piece of work. But actually, the implementation of it is, I think, very complex. And I'm not sure that there are easy solutions, but there needs to be a much more debate about it and much more discussion. When I started out in politics, I stood for Lambeth Norwood, which takes in Brixton. And I was on the Lambeth Police Community Consultative Group at the time of the second Brixton riots of 1986. And you see, the Brixton riots were triggered by a particular incident, which was the shooting of a woman called Cherry Gross, when armed police went to her flat in order to arrest her son, who was believed to be armed. But of course, it had been a complete powder keg for months beforehand, because the police were aggressively targeting in the local community to try to suppress knife crime. Now, 1986 is a long time ago. It's 30, yeah. And these problems are still there in exactly the same form, despite the fact that lots of people have actually made an effort to try to address them.
Yeah.
Thank you very much for your question, Ben. I think we are now going to go, if we can, to Dr. Michael Bowes.
Hello, can you hear me?
Yes, I can. Thank you very much.
Thanks very much. Very much enjoyed that. As you mentioned, one point linked to Brexit is the possibility of Scottish independence. If Scotland were to hold a second independence referendum and it was not sanctioned by the British government, could it ever be held to be legally valid? And if so, how?
I don't think it could be. The power to hold a referendum lies at Westminster. And despite Scottish devolution, the Act of Union doesn't provide for referendums to be held periodically about whether Scotland wishes to remain in the Union. The Union was seen as being permanent. Of course, the reality is that I suppose if a UK government were persistently to deny the Scottish government the power to hold a referendum when the Scottish government believed there was a majority opinion in Scotland for independence, then I suppose we could end up with a situation which happened in 1918 in Ireland, where the Sinn Féin members of Parliament left the Westminster Parliament, went over to Dublin, went to the Mansion House in Dublin and proclaimed the Irish Republic as a unilateral declaration of independence, which then led to violence. But that's a very, very bad outcome to end up with, but it still wouldn't be lawful. It only became lawful when the UK granted the Irish Free State its independent status in 1922. My personal view as a matter of politics is that the UK government would be in some difficulty with devolution and the existence of a Scottish administration and Parliament to continue to deny the Scotland a referendum if the Scottish government had a majority for it. And if, as is possible, the SNP get a majority and it's in their manifesto in May next year, then I suspect we have the makings of a constitutional crisis. I'm a unionist. I don't wish to see Scotland become independent because I think it's going to be very bad for all of us. Bad for England, bad for Scotland, bad for every part of the United Kingdom. And if we think that Brexit is difficult, I think Scottish independence will prove to be even more complex and problematic and deeply divisive. So what do I think the UK government should do? I personally think that there are two courses of action open to the UK government if that happens. Firstly, I think the UK government is entitled, within limits, to postpone that referendum, because I think the argument that the referendum took place in the first referendum was supposed to be a once in a generation event. We certainly haven't had a generation since it took place. So I think there is an argument that rather than saying it's next year or the year after, it can be pushed back, because I think a time for reflection on this is not a bad thing to do. The second thing I think a UK government could do is to argue that there have to be two referendums. So the first referendum has to be on the principle of whether independence is negotiated, and the second has to be on whether the Scottish public wish to go forward with it when they know the terms under which they would actually be departing. Otherwise, we're going to have exactly the same problem. Now, some of my colleagues at Westminster, I've discussed this with them in the past when I was in Parliament, so we don't do that because it's inevitable, therefore, that on the first referendum, people would see it safest to vote in favour of the principle of independence. But I still think that would be better than ending up with a single referendum and the risk of having the unravelling we've had with the Brexit referendum. But ultimately, Scotland is a nation. It has recognisably the attributes of it, and they were preserved deliberately when the Act of Union was signed. And actually, it's a tribute to the success of the Union that the Scottish legal system and various other aspects of Scotland were completely preserved, but above all, the legal system. And so I just don't think it is politically feasible for a UK government to deny Scotland a referendum if there is a majority wanting it. But that having been said, legally, the power is at Westminster. And to answer your question, I think that if the Scottish government were to seek to hold such a referendum without the consent of the Westminster Parliament, what would happen, and it would cause another element of the Scottish constitutional crisis, that somebody would simply take the Scottish government to court and say they were acting ultra vires, and they would be. And the court would have to hold that the Scottish government didn't have the power to do it.
Thank you. We're continuing to get a lot of questions in, and we've still got a few more. Well,
I'll try and keep my answers shorter, and we'll try and get as many in as possible.
We'll I wonder if you wouldn't mind, Master Grieve, just going on a little longer than 7:30.
Of course I will. No problem at all.
Happy to, because this is just fascinating, and I wouldn't want to miss out. Obviously, we can't cover every question, but there's some really interesting discussion going on. Could we go to Mark Shepherd?
Good evening, Master Grieve. Thank you very
Good
much.
evening.
Very insightful. It's been fascinating. But a slightly more political question for you. Back in March 2019, Parliament held a series of indicative votes. And I understand that you didn't vote or abstained against the UK remaining within the customs union in favour of holding a people's vote at that time. I'm just wondering, in hindsight, do you regret that position? And do you think if Parliament had a majority for staying within the EU customs union, we would have ended up staying in it at this moment?
I don't, because I don't really, my own, people may well debate this for years to come. But just to explain how I ended up where I did, when the referendum took place, I was obviously very disappointed with the outcome and very troubled by it. But my initial view was, well, I've got to support the Prime Minister, the new Prime Minister, who was actually an old friend of mine. We've been at university together, in carrying this out. And we've got to try to get as close a relationship as we can with the European Union and try to manage this process which has inherent instability about it. But Theresa May kept on being pressured, particularly by my colleagues in the ERG. And the interesting thing was, I mean, perhaps not just interesting, but the slightly difficult issue was that the more the debate continued, the more binary the nature of Brexit became. And I think the reason for that is that every time you start looking at alternative arrangements to being in the EU, including a customs union or being part of a customs union, this ties you in to a whole series of regulations without having any say in how they're made or created. And you then have to ask yourself the question, if that's going to be our destiny, why on earth did we ever choose to leave in the first place? What are we going to get in return? What is the advantage we're getting if we are in a customs union? And that's bedeviled both sides of this argument. Firstly, it was why the ERG became more and more absolutist in pushing for the thinnest of free trade agreements, which is where we have ended up, and refusing to contemplate the possibility that even a free trade agreement is going to come with inevitable strings attached, which they've largely rejected. And on our side, the Prime Minister moved rapidly away from a customs union, and she moved rapidly away from staying in the single market, and argued that we wanted some special relationship, if I might say, sort of British exceptionalism, entirely tailored to our own requirements. And it was plain to me that this was never going to happen. So my shift, firstly, I became more and more worried about the way the government was proceeding, particularly over the Withdrawal Act and the Henry VIII clauses, and the fact that I could see a real risk that we were going to end up being pushed out of the EU at the end without proper consideration. So my first rebellion was over that, and actually making sure that the EU Withdrawal Act could not be used by means of statutory instruments made under it to carry out our withdrawal without the prior approval of Parliament of the withdrawal agreement in another piece of primary legislation. So that was my first rebellion in late 17. And then when we came to the indicative votes, I have to say that by then, I had taken the view that it didn't actually matter very much if the indicative vote got a majority, because I was absolutely sure in my mind that the ERG were sufficiently strong to destroy it thereafter. I don't think an indicative vote that we wanted to stay in a customs union was going to be particularly helpful to the Prime Minister in bringing one about, quite apart from the fact that she herself didn't believe in it. That's the problem. And that's why I took the view I did. I mean, on occasion, I did support Ken Clarke's amendment. I supported on one occasion, which involved a customs union, but out of loyalty to Ken. But I was never of the view that we were going to get this over the line. And that's why I then started to argue for a second referendum. I failed in that. But do I think it made matters worse? No, I don't think it did. I'm struck by the fact that Peter Mandelson now expresses regret. But you see, this is the regret of the Labour Party. Suppose the Labour Party had come up in 2018 with a clear view as to what they wanted and said to the Prime Minister, we will back you in delivering this. Then the rules of the game might have changed. But seeing that Jeremy Corbyn was in fact a Brexiter, it was perfectly obvious to everybody, and seeing he didn't want to extend any sort of helping hand to the Prime Minister, this was never really going to occur.
Thank you. Shall we try going back to Bobby Shabir? Because I understand a hand has been raised again. So if you would like to ask a question, Bobby, we can get your microphone right.
Yes. Hi. Yeah, my question is, with respect to the Human Rights Act, I may have missed what you mentioned earlier. Do you see, I believe the government wanted to move away from the articles of the Human Rights Act 1998. Do you see post-Brexit any of those articles being preserved, or for us to use any of the articles of the Human Rights Act in future legislation coming forward?
I think I followed that. There was a bit of whistling in the background. The Human Rights Act remains. We've got it. It's going to continue to be invoked. It is often invoked against the government in different settings. And as I said in my talk, I personally think that tinkering around the edges of the Human Rights Act and trying to change it is going to be a very negative process for the government, and it doesn't remove the fundamental problem that we are adherent to the European Convention. So if we end up with a Bill of Rights which is incompatible with the Convention, in the early stages, we're just going to have a flood of cases going to Strasbourg, the Strasbourg court, and the government will then face the political difficulties, as we had, for instance, over in prisoner voting, of what it's going to do about adverse judgments by the European Court of Human Rights, which it has to implement. My view is I think it's very unlikely that this commission process that the government set up is going to lead anywhere. If it does, and the government decides it is going to legislate to remove rights under the Human Rights Act or negate them in some way, then yes, we will be in a new political crisis over that, and ultimately a parliamentary majority can deliver it. But there may well be quite a few Conservative MPs who won't vote for it. I hope that answers your question. I may have missed something in what you said. There was a little bit about the end of saying post-Brexit. I mean, my response is I don't really think that Brexit makes any difference. The two things are unrelated. It's true that we've lost the Charter of Fundamental Rights, and in some cases, there have been instances where individuals have brought claims both under the Charter and the Human Rights Act and found that the Charter has enabled them to get those rights recognised and enforced in UK courts better than the Human Rights Act would do. But they're very unusual. That, of course, will now be gone.
Sure. Thank you, Master Grieve. I mean, my question was twofold as well. The second part of my question was, which I believe the chances are very remote. Do you envisage there ever being a possibility that for us to rejoin the European Union post the divorce being complete?
Yeah, I've got that. Sorry, I missed that in your initial question. I do apologise. Yes, I think it is possible. Politicians, it's a rather bizarre thing about being a politician. Predicting the future is very unwise, but actually some of the things that we have to do as politicians is to try to look at the evidence and make informed judgments as to what the future may or may not bring. Just to go back a moment on the EU, the United Kingdom joined the EEC for very clear reasons in the early 1970s. the UK was underperforming economically compared to our EU competitors, particularly France and Germany. Despite the fact that those countries had been wrecked in the Second World War, their recovery in the late 50s and 60s was giving them standards of living that looked as if their growth rates were considerably better than ours. We had been dependent in the post-colonial era on maintaining a degree of imperial preference for the importation of our foodstuffs from ex-colonies, empire, however you want to call it, giving us cheap food. It was clear that those arrangements were coming to an end. UK industry was aging and was not attracting the investment it needed. And in the early 1970s, most British people travelling on the continent suddenly woke up to the fact that, as I say, our partners, rivals, call it whatever you like, seemed to be enjoying a better standard of living and a more optimistic future than we were. And that's what took Ted Heath and the then Conservative Party into the decision to join the then EEC. And everybody knew at the time it was going to involve some pooling of sovereignty. Now, actually, we've been mightily successful in the EEC/EU. Firstly, we had a profound influence on its development. The single market was created by Mrs. Thatcher because she realised what an extraordinary boost to the UK economy it would bring, as it would make the United Kingdom, with its common law and its being part of the Anglophone world, the primary place of investment for external actors from the EU who wanted to access the EU. And it's exactly what happened. To give you an example, when I was a boy, because I'm partly French by background, 50% of the top American 100 companies had their corporate headquarters in Paris. By the time Mrs. Thatcher left office in 1989, not a single American top 100 company did not have its European headquarters in London. We exploited the EU and the membership of it, and on top of that, although it's never been recognised, John Major, because he was resistant to some of the direction of travel of the EU, obtained some really rather valuable opt-outs. We had the rebate, and indeed we had the opt-outs obtained by John Major, and actually David Cameron's opt-outs, which were rubbish, but were quite important. So we helped shape the EU, and we also had a position that was slightly detached within it, but which was tolerated by our EU partners because they thought our participation in it was so important. Now we're gone. Now, I can't predict the future. I realise that my EU partner, my Conservative colleagues, the Brexit supporting ones, believe with great passion that we can free ourselves from the EU regulatory environment and that we're somehow going to prosper mightily as a slightly buccaneering country on the world stage, whereas the EU, mired in red tape, is going to perform less well. And that is their justification for leaving. Now, I think the next decade will show whether they are right or not. My personal view is I think they're mistaken. I think free trade is a very important principle, but the truth is the world is divided into blocks. We had the advantage of participating in a bloc with like-minded countries that share our democratic values. We're now out of it, yet most of our trade remains with it, or at least the single biggest part of it. And I think we will find over the next 10 years that the world outside is quite a cold and difficult place. And so I think it is perfectly possible, although it depends on your generation, for the younger ones who are here this evening, I suspect in 10 years' time the pressure will build that unless the EU's collapsed under its own problems, that in fact we have to rebuild closer links. What exactly those closer links turn out to be, we shall have to wait and see, and it depends a bit on the form of the European Union has taken by then. But I wouldn't be surprised if in 15 years' time we are not, in fact, in a much closer relationship with the EU again, having chosen to leave it now.
Thank you very much, Bobby. I think we're going to go, we've got 2 more questions, if that's okay, Master Grieve.
Yes, of course.
Taking your evening, but as I say, it really has been fascinating. I think if we could go first to Joey.
Yes, hello, good evening.
Good evening.
Fantastic, thank you. Firstly, please apologise, I can't put my camera on, unfortunately. Otherwise,
don't worry, I can hear you. That's all right.
Excellent, lovely. Thank you very much, Master Grieve. Just sticking on the theme of the Human Rights Act, the Conservative Manifesto made mention of potential changes to judicial review. I just wondered if you thought there needed or even should be changes to judicial review in the process, and if so, what kind of changes would you make?
I'm not sure I would make any changes to judicial review, but I do accept that you can look at some of the detail of judicial review from timing and process and see whether you can make it more streamlined. Judicial review is costly. It's costly for the state, although I don't think we should exaggerate the cost of the state in a country which is splashing out billions of pounds merrily on COVID. I think that the extra cost of coping with JR, I mean, I know it can be onerous on the government legal service. I saw it when I was Attorney General, but I think it's a drop in the ocean. But I can see that you can make arguments that can we improve the process. But ultimately, you have JR or you don't. Attempts to remove the right of judicial review, we saw that in the Internal Markets Bill as well, because it was intended that the Northern Ireland clauses were not going to be open to challenge in the courts, even if they were implemented by statutory instruments. To my view, my opinion, that is a fundamental undermining of the rule of law. And the government was totally wrong about that. But those two, I think, are dead because they disappeared with the offending clauses. I shall be interested to see what Lord Folkes's commission comes up with. I'm not at all clear what's intended. And there have been rumours about the royal prerogative not being capable of being, or some elements of the royal prerogative not being capable of being JR'd. Well, that would be a pretty fundamental shift because they're ultimately unfettered executive powers. It's also been suggested that the government wants to restore the ability, I mean, the government's got a problem because the Fixed Term Parliament Act got rid of the royal prerogative of dissolution. And even if they get rid of the Fixed Term Parliaments Act, the prerogative doesn't revive. So they want to revive it by statute and then prevent the courts from JRing it or looking at it. I don't think that they will find that possible. And it will lead to a constitutional clash, potentially, although may be totally academic, because on the whole, if you dissolve Parliament, there's an immediate general election. But my view is that this is, again, may well turn out to be froth. I shall be very interested to see what they sensibly think can be changed about JR, which does not undermine the rule of law. I personally would not have embarked on this. I think there are more important things to do. But as I say, I might be proved wrong, and I have no idea how the Commission is working.
Lovely. Thank you very much, Master Grieve. And thank you for a fantastic conversation this evening.
Well, thank you very much. I hope, I was conscious there's a huge amount to cover, and I hope in distilling those first 3 themes, there wasn't too much I left out, because I could have gone into much more detail, but then we would have been talking for much, I'd have been talking for much longer. And I wasn't sure that was a very desirable thing to do, because the conversation is much more important. So thank you very much, and thank you for the most interesting discussion.
Thank you, Jay. I think one more question, if we can squeeze it in, Master Grieve, from Victoria.
Hello, Master Grieve. Thank you so much for an awesome event so far. We have really been in for a treat, and you have really touched on so many topics. So I have 2 questions, but I'm going to try to slide them in to short form. Question number one is in regards to trade, and just thinking around the fact that I believe outside of the EU bloc, the US is our single largest trading partner. So do you feel that it is actually realistic and it is a strategy that we should use to try to, I guess, expand or tighten our relationship with trade there? And do you see that this is actually feasible given that we now have President Biden coming in rather than Trump? That's question number one. Question number two is around diversity. I only touched on this because of a question that Ben had said earlier around equality and stop and search and so forth. How do we, or how do you feel, and I know this is a massive question, so you can just give highlights, how do you feel that we get more representation in government? And because those, I guess, like if I take, for example, people who have someone at home that has a disability, I think maybe 1/3 of those in poverty have somebody at home that has a disability. So how do we then get people who represent these different groups more represented in government? I think because that would then help potentially improve policy decisions.
Right, take both those. Start with trade. Yes, the US is our single biggest trading partner outside of the EU, and there's every reason to try to expand trade with the United States. For that matter, I'm in favour of expanding trade with almost anybody if you can do it. I suspect we will get trade deals, for example, with Australia and New Zealand. But the difficulty is that trade, history shows that trade, because of the cost of carriage, is intimately linked to distance. So where you're talking of the United States, the costs of trade are going to be higher than the costs of carrying goods by lorry across the channel. And it's no surprise that France, Belgium, Germany, the Netherlands and Ireland, and to a lesser extent Spain, feature very highly in our trading links. That's because of proximity and complementarity, the fact that our economies have as a consequence evolved so that we produce things that they want and they produce things that we want. The United States has historically been quite a protectionist state. All states have degrees of protectionism, it's just the amount. The UK on the whole has been pretty unprotectionist. But even so, we operated imperial preference, as I was saying, in the days of empire, and we've done it ourselves. I personally think that reaching a trade deal with the US may well be very difficult. It's probably going to be more difficult with Mr. Biden, simply because Donald Trump appears to have had ideological reasons for wanting to produce a trade deal with the UK, which was his hostility to the EU. There's a bit of in-your-faceism by Donald Trump towards the EU. That will not be present. But that's not to say that I think the US will deny us a trade deal, but the trade deal will come with costs attached. And the issue of agricultural produce, which they're very keen to sell to us, and standards is something that I think is going to be quite problematical. So I simply don't know. I don't rule out that we might get a trade deal with the United States, but I mean, it has been a fairly remarkable feature of this saga that so far most of the trade deals we've secured are simply replicating trade deals between which of the EU's already had with third countries. And I think this is, coming back to the question we had before about where will we be in 10 years or 15 years time, this is one of the critical issues. My colleagues with whom I parted company, I think, believe passionately, I have to accept their sincerity, that there's a world out there which is just waiting to expand United Kingdom trade. And we'll suddenly find that we've opened up markets that we couldn't do with the EU and from which we're deriving immense benefits. I just don't share that certainty. So I think that it's unlikely, if we get one, I think it's unlikely to compensate for the trade losses that we may have in respect to the EU. Now, on equality, I think two things. In the first one is that I've been an active participant when I was in Parliament, but I've remained even now that I'm out because I still do mentoring. I was active participant with Operation Blackvote, and encouraging people to consider participating in public life in the UK is sometimes from people who come from communities or backgrounds where they don't think it's ever going to be for them, is something that we ought all to be doing. So, and actually, in fairness, I think a lot more of it has been done than was the case 25 years ago. And the evidence of the consequences of that is in the greater diversity which now exists in the House of Commons, both diversity of gender, but also diversity of ethnicity, background, race, and religion. Now, it's slow. It's a bit like women at the bar. I can't remember the current statistics. I mean, there are a whole series of obstacles to women's progress at the bar, but the number of women coming into the bar as a profession is now the same as men. That wasn't the case when I started out at the bar in 1980, although it was the moment when women were really starting to break the ice. The chambers I went into had only just taken on its first female tenant. These are really, really big changes, and they don't happen overnight. But that's one aspect. But the second aspect of your question is that we have a responsibility as politicians to try to understand others, including people who come from other backgrounds. And whilst that may be a challenge, I don't think it's completely impossible to overcome it. In the same way, but one of the advantages of drawing people in from ethnic minority backgrounds into public life and politics is that it also transforms their horizons about the people they're working with. And that's really important in a pluralist democracy, because the greatest obstacle to the working of a pluralist democracy is incomprehension and lack of contact, because the whole way in which democracy works is that people are constantly moderating each other's views by putting forward an alternative. Sometimes, of course, it can be quite challenging. Black Lives Matter is a challenging movement. But if you're asking me, do I think Black Lives Matter were correct in their analysis about some of the rather blithe assumptions which have prevailed for a long time in the UK about black minority groups and the legacy of slavery, for example, I think they're absolutely spot on. Even if I don't entirely agree with some of the demands that Black Lives Matter have been making, which seem to me to actually be creating gulfs rather than promoting debate. That's my personal view. But yes, that moderation can only come from participation. And so the key thing is a two-way thing. One, you've got to recruit people who may not think that participating in UK public life and politics is for them, and say, of course it is. And I think political parties have been quite good at doing this, although a lot more needs to be done. But the other is about people trying to make sure, if they are in a representative capacity in government or politics, that they understand the communities they represent. I mean, I may give the impression, and I have a very white, conventional, professional classes background and all the advantages that go with it. But the constituency I represented had a very significant ethnic minority element in it, admittedly mainly South Asian, from whom I learnt a great deal in my 22 years in the House of Commons, including quite a lot of close personal friendships. But that was something I was largely ignorant of when I went into the House of Commons, even if my experiences in Norwood and as a councillor in Hammersmith in the 1980s had been my first opportunity as a very wet behind the ears politician to start having some connectivity with people from other ethnic backgrounds, in those days mainly Afro-Caribbean.
Thank you. That's been a good response. Thank you for that. Very insightful.
Thank you so much, Master Grieve. We've gone well over the time that we'd scheduled.
No matter. It's been a pleasure.
Thank you so much for all of the time in answering these questions so insightfully. And I'm sure everyone will agree who had questions. I'm sorry we couldn't get through all of them. I think we'd be here into tomorrow and perhaps even beyond the Brexit transition if we asked all the questions. But thank you to everybody who submitted those questions and raised them. And I'm sure we'll all agree that it was a really thoroughly interesting conversation. And you've certainly shed some light, even if you can't shed all the light that we might want, on where we stand with just 15 days to go before the new year. So thank you so much for giving your time.
It's a pleasure, and a happy Christmas and New Year to all.
Thank you very much.